Hi, this is Brian Bieron with PlatformEconomyInsights.com, and today's briefing is an update on the exciting topic of AB5, the Dynamex decision, the issue of gig worker classification in California. But honestly, this issue is spreading across the country and actually all around the world. And so that's why we're going to spend a little time on it today. So first of all, what is AB5? Well, it's a bill that was just been passed by the California state legislature to put a legislative framework around something called the Dynamex decision, which was a court decision in the California State Supreme Court in 2018 that tightened up the test regarding how businesses should classify workers, mainly whether they can be independent contractors or whether the workers need to be considered company employees. And that actually raises the overall topic. So, why does worker classification matter? Well, when workers are considered to be corporate employees, the company has a number of requirements and mandates, both in the tax space and the regulatory space, that they need to meet. So workers get coverage by laws like minimum wage laws, unemployment insurance, and various benefit requirements, while independent contractors, those are people that take care of those kind of tax and benefit issues on their own. Some people look at that and say, aha, independent contractors are just cheaper, and that's why companies want to use them. When the issue is actually more complicated than that. In many cases, independent contractors are people who like their independence. They work for many different potential employers, either at the same time or sequentially. They like to have the freedom to move between different jobs. There are other issues related to the control that the employer has over the person that gives more freedom to the independent contractor, and the fact that some people just like being their own boss, or also they like the flexibility to work in smaller chunks, sort of part-time. These are all issues that play into the debate and discussion of the role that independent contractors currently play in the modern economy. Now, let's just off the top note that the bill, AB5, has passed the California legislature, and the governor of California, Gavin Newsom, has announced that he will sign it into law. At the same time, the underlying requirements regarding how companies are to classify their workers in California, namely, as I said, the test that was put in place by the Dynamex decision, that's actually been in place since the middle of last year. And so the bill itself doesn't dramatically change that underlying question. Now, the legislation passed the legislature yesterday, and today lawsuits have already begun. There's been a lawsuit filed against Uber by a driver on behalf, at the request of the lawyer and the driver, of the class of Uber drivers in California. So they're looking for a class action lawsuit, an entire other issue related to making these lawsuits more impactful against companies by dramatically increasing the number of people that would be covered. Now, that lawsuit's been filed, and the issue has to do with whether or not Uber should be classifying its drivers as employees rather than independent contractors. Now, I want to mention that before the bill passed, and again, this would be during the time that the Dynamex standard was already in place, but in the run-up to the California legislature passing AB5, Uber and some other digital platforms like Lyft, they publicly stated that regardless of the bill passing, that they would still argue that their workers, or should I say actually, to be clear, the people who are using their platform to drive, that those people, in their view, in the view of Uber and of Lyft, those people are independent contractors, even under the new standard. And it's key to understand that even though the Dynamex decision and now AB5 tightened the standard, it didn't eliminate the ability for a business to hire independent contractors to do work. So Uber has argued, it has stated that they will argue, and they're going to have their chance now because the lawsuit has already been filed. They have argued that even under the Dynamex test, which is called the ABC test for short, that even under that test, their drivers, or should I say the drivers, are still independent contractors. Now, what are those big questions in the ABC test? There are really two that are going to be most important and most interesting on this topic. One of them is whether or not the workers are doing the same kind of business as the hiring business. So in this case, it's pretty clear what the workers are doing. Those are drivers. They're in the business of driving people from point A to point B. Or in the case of Uber's food delivery business, driving sandwiches from point A to point B. Now, is Uber a driving business? Is it a transportation business? We will suspect, will argue that they are digital platform services businesses. That the people who actually are employees of Uber, coders and other business people, that they are in a distinctly different business from the drivers who use the platform. And that is one of the key questions in the ABC test, whether or not the business and the workers are both in the same business, or are they actually in distinct and different businesses. Now, the second test, and again, this is another test that has been traditionally part of litigation over worker classification, has to do with the degree of control that the hiring business puts on the worker who's an independent contractor in their daily course of their job. So employees get directed very closely by the hiring business. But independent contractors are supposed to be independent in terms of how they go about doing their business, how they go about doing their job. Are they independent or not is the key question of this test. And again, we're going to see in the context of each of these different platforms that eventually face this question in California and probably elsewhere in America, we're going to see whether courts believe that the workers are actually independent from the control of the platform. So those are the two big legal questions that are going to face digital platform businesses on the topic of worker classification. Again, number one, is the platform a platform business, or is it in the business of what service the platform actually supplies to users? And then secondly, what kind of control, what level of control does the platform actually put on the people who use it to engage in commerce? And that, honestly, will really depend platform by platform and business by business. So those are the very interesting questions that we're going to see play out in the context of probably this lawsuit against Uber in California and more lawsuits to come. And this is not just, as I said, happening in California. In fact, two recent decisions on the East Coast of the United States, a court case that is underway in Massachusetts regarding Amazon Flex drivers, their delivery drivers that deliver Amazon packages, but do so under the classification of independent contractors by Amazon, and also a case in New Jersey in the Third Circuit regarding Uber drivers And both of these cases focus on a question regarding whether or not these drivers can file their lawsuits as class action lawsuits, and then secondly, whether or not they are inhibited in their ability to litigate based on the arbitration clauses that are in the the sort of user contracts, driver contracts that these platforms use. Both cases have been resolved most recently, and again, nothing's final till it's completely final, but recent decisions in both the New Jersey Uber driver case and the Massachusetts Flex driver case are in the direction of allowing the class action lawsuits and not allowing the arbitration provisions to block litigation. So these are likely to be cited in the court filings in now, for example, this Uber case in California. So with that, these court cases are going to move forward. This is one more reason why bills like AB 5 passing in California and potentially elsewhere in the coming year, let's say, are not the final word, because at the end of the day, whether or not users of platforms are independent contractors or employees tends to actually be quite fact specific regarding both what the platform involved actually does, and secondly, the level of control that the platform actually puts on the people who use it. So, number one, if the platform really appears to be engaged in the operating the same business as their users who are getting paid, that's a check mark in the direction of the fact that these people would be employees. And secondly, if the activities of the people on the platform who get paid is tightly controlled and directed by the platform business itself, that is definitely a check mark in the direction of those users being employees. So with that, this has been an update on AB 5 and the issue of platform gig worker classification in California. But as we know, technology, regulation, and legislation that is going on in California tends to spread elsewhere. So this isn't just about California. This ends up being about America and technology overall. This has been Brian Bieron with Platform Economy Insights. Until our next briefing, if you have any questions, there's a link down below to email platformeconomyinsights.com. I look forward to any questions or comments that you might send in like that. And until our next briefing, bye-bye.